Hello, my name is Brant Hunt, and my channel is Discerning What is True. Um, had a few days off, that is, and had to take care of some things. What I want to do is read from the book called Woe Unto You Lawyers. The chapter is chapter 4. This is a book that was done by Fred Rodell, a former professor of law at Yale University. And again, I'm coming to you live. That is on what I'm going to call dealing with what we call lawyers. Many people put these people on a pedestal as though they really know law, when it's all a game, you see. So, what I want to do, get some papers out of the way here, is to go into chapter 4 and read this to you because most people don't know who Fred Rodell is. And my show is on Discerning What is True. Is also on YouTube and is also on Odyssey. So hopefully you can watch this, and if not, you can watch it later on. That's why I record it. So let's get into the book here, okay? Chapter 4, The Law at its Supremest. We are under a constitution, but the constitution is what the judges say it is. This is based on Charles Evans Hughes, Hughes, a quote. The Supreme Court of the United States is generally rated the best court in the country, if not in the world. Its decisions are supposed to be the wisest, the most enlightened. Its members are kowtowed to as the cream of the legal profession, steeped not only in technicalities of legal logic, but in the wondrous ways of the abstract justice as well. Its powers are enormous. By the margin of a single vote, its 9 members can overturn the decision of mayors, governors, state legislatures, presidents, Congress, and of any other judge or group of judges in the United States. Even the direct will of the people, as expressed in the Constitution and in the amendments, can be brought to naught by Supreme Court interpretation of constitutional language. The 9 men in black robes hold the entire structure of the nation in the hollows of their hands. It would not then seem too unreasonable for any citizen to suppose that the decrees of their decisions must of course be as impregnable to criticism or ridicule as man-made decrees can ever be. Even if it be true that the law in the main amounts to the manipulation of impressive, irrelevant words by a closed corporation of well-trained word jugglers, you see. The law itself, as they Okay, sorry about that. Had an issue here with my computer. Uh, Go back to the chapter here. Woe unto you lawyers! But if by any chance the solemn legal incantation that is of the Supreme Court itself can be shown up as empty, inept, or illogical rationalizations based on nothing more substantial than big words with blurred meanings, then it would not seem too unreasonable for any citizen to suppose that the law as a whole is a lot of noxious nonsense. Practically all of the cases that reach the Supreme Court, and reaching the Supreme Court often means going through 3 or 4 lower courts in turn over a period of years, are one of 3 kinds. there are first the otherwise ordinary law cases which happen to involve people or companies from different states. Iowa farmer makes a contract to sell his hogs to a Chicago packing house, and they get into a fight over the terms. Or a California tourist runs down a pedestrian in Mississippi. Or a New York newspaper publishes a nobility story about a Virginia gentleman, and a gentleman prefers lawyers to pistols. Ordinary little disputes of this nature are handled in the state courts. If the farmer has sold his hogs in Des Moines, or the careless driver has run down a fellow Pasadenan, or the newspaper has written about Park Avenue debauchery, not even the American Bar Association itself could have carried the case to the Supreme Court. But in the early days of the nation, it was supposed, and with some reason, that any state court disposing of its dispute between a logical litigant and a resident of another state might tend to favor the homeboy and give the stranger a raw deal. So it was written in the Constitution that cases involving litigants from 2 or more states might be tried by the federal courts. And any case tried in the federal courts may eventually get up to the Supreme Court. Incidentally, this privilege of taking certain legal squabbles out of the hands of the state courts is all that lawyers mean when they talk gravity of invoking diversity of citizenship. When the Supreme Court deals with a case of this kind, it tosses around such abstract concepts as consideration and contributional neglect, and the rest with the same abandon as does any other court, and it regularly purports to find the specific answers to the problem in some vague but controlling general principle. Yet it is perhaps unfair to examine or judge the court on the score of these cases. In the first place, they are the least important that come before the court. Furthermore, in most of these cases, the court is handicapped, although by a rule of its own making, in being bound to follow the law as laid down by the state courts in previous similar cases. In other words, the court is merely seeing to it that the state law is fairly applied. It is in the other two kinds of cases that come before it, and these include practically all of the significant and publicized decisions that the Supreme Court is really on its own. The second kind of case that regularly reaches the court is the kind that involves some dispute about the meaning of the written laws of the United States, that is. It might seem that Congress, which has nothing else to do but write laws, should be able to set down clearly in black and white what it is orderly done or not done, so that the services of a court would not be needed to tell people what the law means. But the first catch is that these statutes are always phrased by lawyers in Congress or out, so that it frequently does require the service of other lawyers to disentangle the meaning from the verbiage. And when the other lawyers disagree, as they are sure to do if these are fees on both sides of the dispute, then it takes a court, and it may take the Supreme Court, to tell the second group of lawyers what the first group of lawyers meant when they wrote the statute. There is, moreover, another catch, and it was referred to a couple of chapters back. Even when the words of the statutes appear, at least to a no lawyer, to have a perfectly plain and definite meaning, you can never be sure that the court will not you can never be sure that a court will not up and say that these words mean something entirely different. The Supreme Court is no exception. There was the time it said that Section 20 of the Clayton Act meaning literally nothing at all. There was the clause of the Guthrie-Cole Act directly that is part of the act being declared unconstitutional. The rest of the act should go into effect anyway. Meant the exact opposite of what that clause said. And there has been countless other examples of meaning mandling, that is, when the court has undertaken and interpreted the statutes of the United States. For instance, when Congress first passed a estate tax, that's ESTATE, taxing the transfer of money or other property at death, Rich men rushed to their lawyers to find out how they could get around the tax without giving away their wealth before they died. The commonest and by and large the most effective dodge suggested and used was for the rich man to put his property in trust, which of course only meant giving the property to someone else to keep for him by the use of the proper legal rigmarole, and still to keep several strings on the property himself. He might keep the right to take the property back in time he wanted it. He might give up this right but insist on getting the income from the property, which was usually stocks and bonds, as long as he lived. He might keep the right to direct the management of the property, or to say who should get it at his death. At any rate, the idea was that since he no longer owned the property legally, that his legally trustee owned it for him, he couldn't be taxed for giving it to his wife or his children at his death, even though that might be exactly what he had ordered the trustee to do. But Congress, foreseeing some such subterfuge from the start, had written into the estate tax law in legal but comparatively comprehensive language a special provision. The provision was that any transfer of property, even though not done in the usual way of making a will, which was intended to take effect in possession or enjoyment at death, should be soaked under the estate tax. And very soon the question arose and was carried up to the Supreme Court whether a estate tax had to be paid on property that a man had put in trust, ordering the trustee to pay him the income as long as he lived, and then to turn over the property to his son at his death. Certainly, this would seem to be the one of the exact similar situations that Congress has been talking about. The man kept right on enjoying his interests and his dividends until he died. The son was not even privileged to smell the stocks and bonds until at his father's death they were turned over to him. From his standpoint, it was the and not until then that his possession and enjoyment of the property took effect. Not at all, said the Supreme Court in Consensus when it was asked to interpret it and apply the statute. In the first place, we have general principle to the effect that tax statutes are to be strictly construed in favor of the taxpayer. True. We also have a general principle of statutory construction, not to the effect that words are to be read in the light of their customary, and accepted meaning. Presumably, the court did not care to deny that enjoyment meant enjoyment, but the prior principle seems here to carry more weight. Sorry, the fact that various state courts had interpreted identical words in their state death tax statutes so as to cover the type of transfer here at issue. The state courts had almost unanimously is not controlling upon us, the Supreme Court. Finally, there is a compelling fact that the decedent, that is the one who's died, passed away, has completely divested himself in title to the property before his death. Indeed, he had, according to the law, but Congress has said nothing about legal title. It was the taking effect of the enjoyment that was supposed to matter. And at any rate, concluded the non-salons, the Dodge works, the statute doesn't cover this case, no tax. The payoff came to the very day after the decision was handed down. On that day, Congress amended the statute so that the estate tax even more specifically applied to transfers of property in which the original owner hung on to the income for himself until his death. Of course, a couple of tax lawyers hopefully asked the Supreme Court to rule that under certain circumstances, at least this didn't mean what it says either. But this time the court upheld the tax. This time the second principle of statutory construction, as outlined above, outweighed the first principle. For yet another example of Supreme Court interpretation of written laws takes the old congressional statute still in the books, which says that collection of federal taxes may not be enjoyed in any court, a legal injunction being, of course, no more than a court order forbidding someone from doing something. The idea, whether wise or unwise, was to keep innumerable injunction suits from holding up the collection of federal revenues. You see. If a man or a company through a tax thought a tax was too high or too big or too raw or just plain illegal, he was supposed to pay it anyway and then sue them to get it back. Certainly the statute itself was and is so short, blunt, and simple that no sensible person, no non-lawyer that is, could possibly miss its meaning. But strangely enough, the commonest way of protesting a new federal tax today is to sue for an injunction. The Supreme Court, in the course of interpreting the statute in the light of general principles of law, has so cluttered it with exceptions that the exceptions all but blot out the statute. Examples can be multiplied almost indefinitely. For when the Supreme Court set out to tell Congress and the world what an act or Congress really means, only the sky and such abstract legal principles as can be drawn from the sky are the limit. And all that Congress can do after such an interpretation is patiently to amend or rewrite the statutes with the permanent hope that maybe this time the words used will mean the same thing to the Supreme Court that they meant to the Congress. But in the third kind of case that takes up the time of the Supreme Court, there is no getting around afterward. There's no getting around afterwards than what the court has decided. There's no getting around these decisions, that is, short of amending the Constitution, changing the judges who make up the court, or most difficult of all, changing the judges' minds. The third kind of case, the most important of all, includes all those disputes, I should say, in which someone claims that a state law or a federal law or some action taken under such a law offends the U.S. Constitution. Here, the Supreme Court has the final word, you see. What it decides and what it says in these cases make up that holy bunk, or holy hunk, I should say, of the law known as constitutional law. From the practical or non-legal viewpoint, constitutional law adds up simply to a list of all those instances where the Supreme Court has said to Congress or to a state legislature, you may not enforce that statute, or where it has said to a federal or state executive officer or administration board, you may not carry out that ruling. The instance where the court has said you may don't count from a practical viewpoint, there the situation would have remained exactly the same if the Supreme Court had never said anything. And it is worth noticing that only governments or people who are performing government jobs ever get spanked by the court for being unconstitutional. The Constitution protects within limits, that is certain limits, free speech, but a man who holds his hand over another man's mouth to keep him quiet, though he may get hauled into court for minor assault and battery, will never get charged with violation of the Constitution. Thus, what constitutional law deals with is the restriction on certain forms of government actions which are laid down in the name of the Constitution by the Supreme Court, which is, although many people are prone to forget this, no more than one branch of the federal government itself. And all that constitutional law, taking in the more legal sense, amounts to its cumulative effects, or efforts, I should say, of the Supreme Court to explain, justify, or excuse the restrictions it lays down. Now, the basic theory of all constitutional law is both simple and sensible. It is that if Congress or any other state or city or village enacts a law that is forbidden by the Constitution, that law might just as well never have been enacted. It can be ignored. It is no good. It is unconstitutional. But the fireworks start when it comes down to a question of who is going to tell whether laws are unconstitutional and how. For the Constitution itself, as is little realized, nowhere gives that right to the Supreme Court. The Supreme Court early assumed that right so far as state laws were concerned, and nobody objected much because neither Congress nor the president wanted to bother to check up on state laws, you see, because it was part of the federal government. But the Supreme Court was much more cautiously when it came to telling Congress and the president that federal laws were unconstitutional. Only once in more than 60 years after the birth of the nation did the court dare repeat that it thought an act of Congress was improper, and the habit of informing the other two branches of the government that some measures, that is, they have had approved, was downright illegal. Never really blossomed into full flower until the 20th century. It is still at least it is still at least arguably that Congress or the president or the two of them altogether have as much right, as much ability to decide whether a proposal federal statute disobeys the Constitution or not, as have the 9 bold men. Yes, granting that by custom is by nothing more than the last word does belong to the Supreme Court. The question remains, how and how well has the court exercised this powerful privilege as applied to the laws of the states as well to those of the nation? Have its constitutional decisions been models of logic, statesmanship, and justice? Or have they perhaps been cut out of the same old legal cheesecloth, that is, abstract concepts, ambiguously words, and ambiguously principles? There are some parts of the Constitution that are written in such plain language that nobody, not even a lawyer, could very well mistake what they mean. There is, for instance, the provision that the United States shall not grant titles of nobility. There is a provision that, did you hear that? Let me say it again. There is, for instance, the provision that the United States shall not grant titles of nobility. There is a provision that each state senator's term shall be for 6 years. There's a provision that the state shall not coin money. Obviously, if Congress had voted to make Charles Lindbergh a duke instead of an army colonel, or if a federal statute were passed extending all senators' terms to 8 years, or if the Oklahoma legislature were to enact a bill to set up a state mint and start turning out silver dollars, any of those laws would be clearly unconstitutional. But if it would scarcely be necessary to ask the advice of the Supreme Court on such matter, any some moron could give the right answer. There are other parts of the Constitution that are not written so plainly. It may be that they use hazy legal words, or maybe that the words they use, though fairly clear at the time of writing, have since acquired a nebulous quality through constant legal mastication of their words or their meanings. It is out of these parts of the Constitution, and for that matter, out of parts that are nowhere written in the document at all, that constitutional law is really built. Whenever a lawyer appears before the Supreme Court and asks the court to declare a state statute unconstitutional, the chances are better than 10 to 1 that he is basing his plea on the 14th Amendment to the Constitution. The chances are almost as good that he is basing his plea on one little clause out of one of the 5 sections of the longest of all the amendments. The chances are in short that he is claiming that by the statute in question, his client has been deprived of property without due process of law. For most of constitutional law is applied to state statutes and is laid down by the Supreme Court revolves around that little phrase. On the basis of that phrase alone, the court has killed hundreds upon hundreds of state attempts to regulate or tax business and businessmen. As a matter of fact, it's practically impossible for a state to pass such a statute today without having a legal howl carried to the Supreme Court to the effect that the statute violates the due process clause of the 14th Amendment. According to his official interpreter, does the little clause mean? When is a deprivation of property not a deprivation of property? Surely every tax is, in a sense, a deprivation of property, and some state taxes are perfectly legal. And what is implied by that lovely limpid legalism, due process of law? To help us answer these questions, the Supreme Court has evolved and will be a big surprise, a batch of general principles. There is the general principle that a regulation which is a proper exercise of the state police power is valid, but that a regulation which does not fall within the police power is the deprivation of property without due process of law. There's a general principle that businesses affect with a public interest may, by and large, be regulated, but that to regulate a business not so effectively is ADOP, WDPOL. There is a G.P. that a tax on anything other which the state has jurisdiction is proper, but a tax on something other which the state has no jurisdiction is a DOP, etc. and so on. Of course, just what state police power is and just what a business affected with a public interest amounts to, and just what state jurisdiction to the taxes mean is, in each case, another and a longer story. There are sub-principles and sub-sub-principles and exceptions, you see. And of course, too, there is not a word in the Constitution about police power or businesses affected with public interest or state jurisdiction to tax. But this fact does not stop the Supreme Court from using such concepts as the basics of constitutional law. Even the highest court in the land, laying down the supreme law of the land, also reverts to the same old hocus pocus of solemn words spoken with a straight face and meaning intrinsically nothing. If this indication sounds too strong, consider what a member of the court once had to say about the use to which his brother put that little clause of the 14th Amendment. You remember, these are the words of a late Justice Holmes. Remember, he's already talked about Justice Holmes. I am not yet, this is a quote from him, I am not yet adequately expressed the more than anxiety that I feel at the ever-increasing scope given to the 14th Amendment is in cutting down what I believe to be the constitutional rights of the states. As decisions now stand, I see hardly any limit but the sky to the invalidating of these rights if they happen to strike a majority of this court as for any reason undesirable. Of course, the words due process of law is, if taken in their literal meaning, has no application to this case. We should be slow to construe the clause of the 14th Amendment as committing to the court with no guide but the court's own discretion, the validity of whatever laws the states may pass. Justice Holmes' brief warning about the temptation to follow personal preference when the law is so amorous and indeterminate was spoken as usual in dissent. But what did he imply by his reference to the words due process of law? If taken in their literal meaning, what did that little clause of the 14th Amendment, since inflated by the Supreme Court to tremendous significance, originally mean? It makes an interesting story. The 14th Amendment was one of those three amendments added to the Constitution shortly after the Civil War to protect the civil rights of the Negroes. The first of its 5 sections including the command, presumably intent to prevent persecution of the ex-slaves, nor shall any state deprive any person of life, liberty, or property without due process of law. But the words used in that clause had appeared in the Constitution before. They had appeared in the 5th Amendment as part of the original Bill of Rights. They are 77 years before the 14th Amendment was adopted. It was decreed, nor shall, in parentheses, any person being compelled in any criminal case to be a witness against himself, not be deprived of life, liberty, or property without due process of law. Because the 5th Amendment was said to restrict only the federal government, it was first necessary to replace the same restrictions on the states, that is in the 14th. What, then, was the due process business intended to mean? How did it happen to have been coupled with the prohibition against making a man take the stand against himself in a criminal trial? It was no accident. For due process, before the Supreme Court began to build general principles around it, meant nothing more complicated than proper procedure. Okay? Proper procedure. And being deprived of life, liberty, or property without due process of law meant only being hanged, H-A-N-G-E-D, that is deprived of life, jailed, deprived of liberty, or fined, deprived of property, without a proper trial. That's what it meant. Thus, the due process clause was originally intended to apply only to criminal cases. The idea that any statute must less a non-criminal one, like a tax or a regulation of business, after being properly passed by a legislation signed by a governor and enforced according to its terms by judges, could amount to a deprivation of anything without due process of law, when once had been laughed out of court. Yet, the Supreme Court has built the bulk of its constitutional law as applies to the states on precisely that strange supposition. It has taken a simple phrase of the Constitution, which originally had a plain and precise meaning, twisted that phrase out of all recognition, ringed it around with a vague general principles found nowhere in the Constitution, and then pontification and then pontifically mouth that phrase and those principles to excuses for throwing out or majestically upholding state laws. Nor should it be supposed that the silly house of cards logic of constitutional law works only in what might be called unprogressive ways. Remember, this is a progressive court with Judge Holmes in the early 1900s. True, most of the state statutes the Supreme Court has condemned as violating the Due Process Clause of the 14th Amendment have been such measures as minimum wage laws, laws protecting labor unions activities, laws and rules setting public utility rates, certain types of use of income, and inherited taxes, and other restrictions on the business of making money and keeping it. But as mentioned before, the word magic of legal process recognizes no socially significant limitations, you see. Constitutional law can be just as illogical and irrelevant on the liberal side. There are, for instance, as few people are aware, no words anywhere in the Constitution protecting freedom of speech, freedom of the press, freedom of religion, or freedom of assembly against infringements by the states. The sole reference to those civil liberties in the whole Constitution is in the First Amendment. All that the First Amendment says is that Congress shall make no laws respecting a establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peacefully to assemble and petition the government for redress of grievances. Yet, as almost everyone is aware, the Supreme Court has, on occasion, protected civil liberties against infringements by state law or by city ordinance, you see. That is, cities being considered legally as merely subdivisions of states, subject to the same constitutional taboos. Huey Long, that is the former governor of Louisiana, attempted to gag the opposition press under a Louisiana statute was called unconstitutional by the court. So were Mayor Hague, Hague, efforts to clamp down on freedom of speech under a Jersey City ordinance. While unconstitutional, as much as it was surely not Congress that passed either of these measures, the answer lies once more in the well-worn Due Process Clause of the 14th Amendment. Laws such as these, said the court, deprive people of liberty without due process of law. A worthy sentiment, unquestionably, but just as illogical and just as unwarranted by the true meaning of the constitutional phrase as all the others and less popular due process decisions. There is, moreover, a clear danger to leading the protection of civil liberties against state infringements to the whims and general principles and legal logic of the Supreme Court. Instead of writing into the Constitution that should have been done long ago, a broad and definite protection of these liberties against all infringements, just as the court had held that some state restriction of freedom of speech and the rest are bad under the Due Process Clause, so it can hold and has held that other restrictions are not outlawed by the 14th Amendment. Where the logic of the legal rule is so tenuous, the court can blow now hot, now cold, as true practicality all constitutional law. It is impossible to tell what the court is going to do when they call it unconstitutional, until the court has gone into a trance and invoked a spirit in the shape of a controlling principle. Though the bulk of constitutional law as applied to states stems in its mystical manner from the Due Process Clause of the 14th Amendment, its parent clause in the Fifth Amendment has not been used or needed so often as an excuse for calling federal laws unconstitutional. Railway workers were doubtless interested to learn that the congressional outlawing of yellow dog contracts, that is, contracts forbidding memberships in the labor union, deprived the railroad companies of liberty and property without due process of law. Women who worked in Washington, D.C. were doubtlessly fascinated to hear that their employers had been similarly deprived by a congressional act setting minimum wages for women. For setting minimum wage for women. Both the railroad men and the Washington women were probably especially impressed to be told by the Supreme Court that anti-union discrimination and sweatshop wages were protected against congressional interference by none other than the American Bill of Rights, of which the Fifth Amendment is, of course, a part. But the Supreme Court pet reason for calling federal laws unconstitutional is even more complicated than the due process gag, and even harder to trace back to the Constitution itself. The general idea is that the federal government may not do anything that the Constitution does not specifically say it may do. This notion is what's known as a strict construction of the Constitution, and it is all mixed up with the slogans of states' rights, which is very nice and very handy political slogan for those who do not like what the federal government happens to be doing at the moment. So what he's saying here is the general idea is that the federal government may not do anything that the Constitution does not specifically say it does. So when the Constitution is there, it cannot stretch the bounds. It can't go any further than what it says. Very strict in that way. The chief reasons usually given by the Supreme Court for backing the strict construction principle instead of the contradictory loose construction or led the federal government to do anything the Constitution doesn't say it may not do principle are two in number. The first reason is that the founding fathers in persons were strict constructionists and intended to hogtie the federal government when they wrote the Constitution, but that every historian knows is utterly nonsense. The founding fathers, almost to a man, avowed enemies of states' rights, were out to give the federal government all the rope they could possibly give it. Still, the present use of the due process clause indicates a little matter like historical inaccuracies and never allowed to interfere with general principle of law. The second reason the court gives for its zealous protection of states' rights is the constitutional 10th Amendment. These amendments began to look more important than the whole original Constitution and to any of the legal tribe they are. What the 10th Amendment says is the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. So far, so good. But the question remains, what powers are delegated to the United States by the Constitution? And it is answering that question which is left hanging in midair by the 10th Amendment, and which is more confused and clarified by the rest of the Constitution. That the court has so often performed back somersaults of logic right into the camp of the strict constructionists, all of course in the name of the law and the founding fathers. There is, for instance, a clause in the Constitution that is the original Constitution for change to the effect that the Congress shall have power to lay, collect taxes, duties, imposes, and exercise to pay the debts and provide for the general welfare of the United States. Lawyers and law professors and judges have written tracts and treatises and whole books about the meaning of this clause. The strict construction boys say it means that Congress can collect taxes, etc., in order to pay the debts and provide for the general welfare of the people. The loose construction of it, boys say it means that Congress can collect taxes and also pay debts, and also with laws, they aren't necessary tax laws provide for general welfare. You can guess which side of the Supreme Court is on. Why? Why? Because that's what the founding fathers meant, which in a matter of historical record, they almost surely didn't. And because of the 10th Amendment, which is obviously has nothing whatsoever to do with that case. It was on a line of so-called reasoning of this sort, only more extreme, that the Supreme Court threw out the original Agricultural Adjustment Act. And this despite the fact that the Congress, well aware that the court would only let it provide for the general welfare in tax statutes, and passed the act as a tax on farm products. It proceeds to go as bounties to those farmers who cut down the acres of their crops. Now, many people thought the AAA, that is the Agricultural Adjustment Act, unwise and rejoiced at the Supreme Court decision. But even they would admit that it is certainly not the job nor the right of the Supreme Court to judge the wisdom or the foolishness of laws. That supposedly is Congress business, you see. The courts, as it has been proclaimed countless times, can only decide whether a law is constitutional. Here's why, according to the Supreme Court, the AAA was unconstitutional. It used federal tax money to accomplish an unconstitutional purpose. What was that? That's right, federal regulations of farmers. Why is federal regulations of farmers unconstitutional? Because regulation of farmers is exclusively the rights of the states. Why? Because of the general principle that the federal government is a government of limited powers, strict construction, that is, because of the founding fathers. Yes, and specifically because the 10th Amendment reserves to the states those powers not delegated to the federal government. Well, is it one of the powers delegated to the federal government, the power to collect taxes and obviously spend them, promote the general welfare? Granted, then why isn't the AAA, the Agricultural Adjustment Act, whether you like it or not, an exercise of that power, or do you mean that giving bounties to certain farmers does not, in your judgment, promote the general welfare? No, says the court. We are not now required to ascertain the scope of the phrase general welfare of the United States or determine whether an appropriation in aid of agriculture falls within it. Then why, in heaven's name, isn't the AAA perfectly constitutional as a tax to promote the general welfare, which you grant Congress has the right to enact? Because it used the tax money to accomplish an unconstitutional purpose, namely federal regulations of farmers. And there set the Supreme Court at the end of the opinion exactly where it had stated, after one of the most perfect examples of arguing in a circle that any court has ever indulged in. But plenty of long words and solemn spoken principles of law gave the circular reasoning an act of great depth and respectability. After all, the court was only patiently explaining that the Constitution clearly forbade Congress to enact the Agricultural Adjustment Act. Any lawyer at least would understand. Another power given to the federal government by the Constitution is the power to regulate interstate commerce, because that power is granted very specifically and plainly. Many of the most important federal statutes are fashioned around it, but you can't get by the Supreme Court that easily when the court is out to lay down constitutional law. When Congress tried to discourage child labor by forbidding the shipment of things made by child labor in interstate commerce, the court calmly said this is no regulation of interstate commerce. It's just a nasty old invasion of states' rights, and it's unconstitutional. There were, of course, general principles which controlled. When Congress didn't put a high tax on child labor, figuring that it still retained the power to levy taxes at least, the court said this is no tax. It's a regulation, and it's still unconstitutional. And so saying, the court conveniently ignored the fact that it had previously let Congress, by exactly the same device of a high tax, put an effective stop to the issuing of state bank notes and to the sale of yellow oil and margarine, that is, which was passed off as butter, and to the interstate shipment of opium and other narcotics. In those cases, presumably, the controlling principles were different. It is moreover worth noticing, that is, as it indicated the tremendous power of those non-anointed lawyers, that despite efforts to amend the Constitution, child labor still flourishes in this country more than 20 years later. Just because the courts once said that the Constitution protects the sacred right to employ child labor against any nefarious attempts by Congress is to interfere with that right. And similarly, it took almost 20 years before the Constitution was amended to allow a federal income tax, after the court had solemnly figured out through a series of abstractions to be recounted here, and the original Constitution forbade Congress to tax citizens' income. It was under the court's interpretation of what the Interstate Commerce Clause did not mean that such New Deal laws as the National Industrial Recovery Act and the Guthrie-Cole Act met their debt. It seems there are two principles. One is that Congress may regulate anything that affects interstate commerce directly. The other is that Congress may not regulate anything that affects interstate commerce only indirectly. Of course, there is not a word in the Constitution itself about direct or indirect effects or interstate commerce, but that does not keep those efforts from being a very vital consideration in constitutional law. Applying these principles, the court said that working conditions in companies doing interstate business affected interstate commerce only indirectly. So it was perfectly apparent that the NIRA and the Guthrie-Cole Act, both which made bold to regulate those working conditions, were downright unconstitutional. But by the time the Wagner Labor Act came along a couple years later, working conditions in companies doing interstate business suddenly acquired a direct effect on interstate commerce. And so a law regulating those conditions was perfectly constitutional. The relevant principles of constitutional law remain, of course, unchanged. It was merely that this time a different principle was controlling. There was, moreover, a second reason why the NIRA was unconstitutional for the court. Is not always content to kill a law with one shot of constitutional principle. The second reason is especially interesting because it involves one of those chunks of constitutional law that is not even remotely derived from anything written in the document that most people think of as the Constitution. The court just makes this thing up all by itself. The basic principle that the court makes up this is that Congress may not delegate or hand over any of its lawmaking powers to anyone else. Now, is it clear that if this principle were really followed, there wouldn't be any United States government? All the thousands of rules and regulations and orders, every one of them that are formulated day after day by every branch of the government, by the commissions like the Interstate Commerce Commission and the Federal Trade Commission, by the departments of all 10 of them, that is, and by the branches and bureaus of the bureau departments, like the Patent Office and the Coast Guard and the rest. All these rules and regulations would have to be passed by Congress itself. It is only because Congress has always delegated the largest part of its lawmaking power after laying down the broad and general outlines of a law that the federal government has been able to function at all. But the Supreme Court, as might be expected, has an answer to tell us, that is, to all of this, that is. It is to form a sub-principle of exception to the primary principle. It is that Congress may delegate to other people the powers to fill in the details of a law, but not the power really to make a law. That lets out all the commissions and the departments and the rest, and doubtless lets Congress breathe a lot easier. But when the NIRA came up for a review, despite the fact that Congress has certainly passed a law and, as usual, filled numerous pages with its written provisions, the court said Congress was handing over its law-making powers to the keepers of the Blue Eagle. Why the Recovery Administration was really making laws, whereas the National Labor Board, for instance, is merely filling details or filing details. Only the Supreme Court knows, and it won't tell. It's much too busy expounding constitutional law. Now, what he's talking about simply is what took place during the Depression. Major things took place in the Depression era, and the court became more lenient in a lot of ways to powers. And this was not good, in my opinion. I've always believed simply if it doesn't say that the federal government, the central government has this power to do such and such, then it is to the state. It goes to the state. It's voided to the federal government. It goes to the power goes to state power. Perhaps the best known of these pieces of the highest law of the land that the court has manufactured out of ether logic with no help at all from the words of the document is the piece that deals with the federal government taxing the state government and vice versa. It is all started with Chief Justice Marshall, famous from a mine, that the power to tax involves the power to destroy. Therefore, argued Marshall this is Marshall just after the Constitution, after the country started. This is roughly 25 years later, maybe a little longer. Thurgood Marshall, that is. With his court chiming in, we can't have the states laying taxes on the property or the activities of the bounds of the employees or the federal government, and we can't have the federal government levying taxes on the states either. Or if we allow such taxes, one of our governments might incidentally destroy the other. Even if there isn't anything about it in the Constitution, such taxes are unconstitutional as a matter of principle. It developed, as it always does, that there were sub-principles, you see. The court discovered one of the effects that the federal government, while it could not tax the government functions of the state government, could tax the non-government functions of the state government, which may sound confusing to a non-lawyer in that it is hard to think of something done by a government being non-governmental, but which was perfectly clear to the Supreme Court. Also, while a direct tax levied by a state on something connected with the federal government was all wrong, an indirect tax was all right. Now, for some reasoning wrung from the metaphysical reaches of constitutional law, the court considers an inheritance tax an indirect tax. Therefore, any state can slap on a tax when a man dies and leaves his federal bonds to his wife. But since an income tax is a direct tax, no state can tax the man or his wife either on the income he makes from those federal bonds, presumably going back to the primary principle, such as a tax might destroy the federal government. The corresponding immunity of state bonds from the federal income tax raises yet another question. Can you necessarily change the Supreme Court notions about constitutional law even by amending the Constitution? Well, apparently not. For the income tax amendment gave Congress the power to tax incomes from whatever source derived. See, the words could scarcely be plainer or stronger, and part of the reason for writing them was to put an end to the immunity rule so far as the federal income taxes were concerned. But the court still says that it is unconstitutional for the federal government to tax the income from state bonds. Thus, the unwritten piece of the Constitution that the court discovered all by itself carries more weight with the court than the written words of the document. Finally, there was the time the court was called upon to decide the delicate question whether the salaries of federal judges could be taxed under the federal income taxes. The judges were not part of any state government, so they could not come in under the mutual immunity rule. But there was another opening, you see. The Constitution says that the salaries of federal judges may not be reduced while the judges are in office. Aha, says the court. To make us pay income taxes on our salaries the way everybody else does would clearly be just the same thing as making us take our salary cut. That obviously would be unconstitutional. Of course, there was still that little phrase in the amendment about incomes from whatever source derived. But the strange reversal of a customary reasoning, you see, the court seemed to feel that the old no salary cut clause amended the amendments instead of vice versa. Again, doubtlessly a matter of principle. Wow. Yeah, their principle. So runs in the brief. So runs in the brief the story of how constitutional law, the highest law of the land, is laid down by the Supreme Court of the law of the land. Here's the law at its best. Here are the lawyers at their most distinguished, their most powerful, still comparing piles of abstract, indecisive, and largely irrelevant principles as though they were matching pennies on a street corner. Still draping in the longevity language of a generalized logic, the answers, some good, some bad, to specifically social problems, and proposing all of the while to be applying the commands, prohibitions of U.S. Constitution. No wonder Charles Evans Hughes, long before he became the Supreme Court Chief Justice, was once blurted out with a bluntness that is rare in lawyers. We are under a Constitution, but the Constitution is what the judges say it is. You see, that's not what it's supposed to be, but that's what it's become. They've had enormous immunity. And of course, the judges themselves, as could scarcely fail to occur when the rules of the game are so vague, are forever disagreeing about what the Constitution is. Every man on the street has heard of the 5-4 decisions, the dissenting question, dissenting opinions, that is. But a dissenting opinion, though it may make its author feel a lot better for having written it, in its essence, no more than a critical, occasional literary essay. What is said by the 5 or 6 or 7 or 8 justices who voted the other way is the law. It is just as much the law so far as the case is concerned as if the decision had been unanimous. Thus, it can happen, and has often happened, that one man, one judge, holds the meaning of the Constitution in his hands. This possibility was never more strikingly illustrated than when, less than a year after the court called a New York minimum wage law for women unconstitutional, they called a Washington state minimum wage law for women's constitutional. All because one man, Justice Roberts, voted on the other side. It seems that the New York statute deprived employees of their property without due process of law and therefore violated the 14th Amendment, whereas the almost identical Washington statute was a proper exercise of the state police power and therefore didn't violate anything. Of course, it was not the principles, the basic law, that changed with Justice Roberts' mind. It was merely that in one case, one principle was controlling, in the other case, it gave way to different principle. And it's worth repeating and remembering that the alleged logic of constitutional law is equally amorphous, equally unconvincing, equally silly, whether the decision the court is handling down are good or bad, progressive or reactionary, liberal or liberal. The principles under which the Washington minimum wage statute was blessed had no more to do with the problem or with the Constitution than those under which the New York minimum wage statutes were damned. The Wagner Labor Act was called constitutional for no more solid reason than there was which the Agricultural Adjustment Act was called unconstitutional. Freedom of the press in Louisiana was was defended by logic no less far-fetched than which upheld the freedom to employ child labor. No matter in which direction the legal wand is waved, the hocus pocus remains the same. There is one more principle of constitutional law that is worth mentioning, although it has been rather sadly neglected. It is that any law, state or federal, is entirely proper and valid unless clearly and unmistakably forbidden by the words of the Constitution. But then, if this principle were regularly followed, there would not be much use for any of the other principles, you see. There would not be much constitutional law either. So that's the chapter 4 of the day. As I was reading from a book here from, my mind has slipped here, deal with what I call the issue of woe unto you lawyers. What is interesting simply is that how the Supreme Court has become very progressive basically ever since the Wilson administration, but enormously began to make its changes in the under the Roosevelt administration, and then it got to the point recently, I mean not recently, but in the last 30 years, it's been enormously progressive in its way of looking at things, and it allows a loophole until we recently had the issue. What was it, a year ago, maybe, to deal with abortions, completely turning over the Roe and Wade decision, which was quite surprising for me because I didn't expect that to happen. And is that a turn back to a conservative perspective? I don't know. Or is it based upon mainly the last with Trump stacking the court? That is, not stacking, but getting his more conservative, quote unquote, court justices to be involved. I don't know. But anyway, I hope that you guys had a good day. It's been a good day today, beautiful weather. And I just want to do this today. Again, this is Woe Unto You Lawyers, Chapter 4 by by Mr. Fred Rodell, professor at law, Yale University. It was written in 1939. So this is also going on, which is Fred Rodell is talking about. One more thing and I'll stop. It is actually during the Roosevelt deals, but the court has already become very much progressive ever since the Wilson administration. They continue on that track, and then it got really, really radical in this time. And I think this Fred Rodell was pretty much frustrated by what he was seeing. So again, this statement here is from Luke chapter 9:52. The Bible. Woe unto you, lawyers, for you have taken away the key of knowledge. You enter not in yourselves, and them that were entered in you hinder. Enormous power. And speaks out simply that lawyers themselves are, in my opinion, are simply crooks who use law to allow crookery to take place. That's what it's about. All right, take care. Have a good night. We'll talk to you later.